Hi, my name is Tim Lowe, and I'm holding here in my hands an oath of office for Sheriff Kendall Allen, who up until March 12th, 2014, was a pretender as the sheriff of Stevens County. He had not filed his oath of office or taken his oath of office. And he executed a raid on 5 people in the city of Kettle Falls over a medical cannabis grow. They had originally had the sheriff's deputies come into the house. The helicopter had flown over. It was a Customs and Border Patrol helicopter, seen their plants on the ground, grown in the ground, and had come in immediately to execute a warrant, executed a warrant, and found that they had 10 people at the grow, and they had, I want to say it was 100 plants. They had told them that they had too many and had them cut down 25 plants. They had a federal agent at the scene at both incidents, and the deputies were deputized as federal agents, violating the state law and the state constitution, which of course the sheriff had not taken an oath of office to. At the point where he came in and raided these people the first time, he told them that they were within compliance of Washington state law if they cut down 25 plants. They wanted to be in compliance, so they cut down the 25 plants. The problem that we have here is that the sheriff, who had no oath of office in place, I'm holding it here, wasn't subscribed and sworn to before March 12th, 2014, and this raid occurred in 2012. So 2 years before his oath of office was actually filed, he came into these people's homes, raided them, and from that raid decided to go after several long-term criminal sanctions. One of the gentlemen is facing life in prison, who's actually a fairly young guy. Another of the 5 people, the others are facing 20 to 40 years. One of the gentlemen is 70 years old, medical cannabis patient, who is now facing a 40-year prison sentence, which of course would be life in prison. Let's really call it truly what it is, life in prison. All from a sheriff who had no right in any way, shape, or form to investigate anyone, since he had no oath of office in place. And the Washington State Constitution, which is what the medical laws are based around, is very specific in that we can create our own laws in the state of Washington. And because we can create those laws according to the Washington State Constitution and a People's Initiative, which was what I-692 was, Initiative 692, back in 1998, was the law that allowed medical cannabis use by medical cannabis patients. We have the sheriff's deputies saying that they were operating within the confines of the law. Once they cut down their plants, they cut those down. And then you have the federal government moving in to then take the plants away from the people and to arrest them. The issue becomes very specific to a rule of lenity, which would basically say that if they thought they were following the law, they can't be convicted of a crime as if they were not following the law. The truth is, the rule of lenity does apply in this case, and not one attorney has brought the rule of lenity argument into it. And also the silver platter doctrine, when we have state agents hiring the helicopter to fly over and then turning around and not having a state case to go after them and deciding to go after these people with a federal case and giving the case over to the feds. It's called the silver platter doctrine, and they're violating both. They're violating the rights of the patients, and they are in essence in restraint of trade and commerce by not allowing us to have our 10th Amendment right to have an experiment in trade and commerce. And so these people are not doing anything wrong. They didn't harm anybody. There's no controlled buys in this case. This is strictly a case of medical cannabis patients providing for medical cannabis patients directly. And they had a one-time grow for the year. That's why they had everything in the ground. They were actually not over their numbers, and the sheriff was in error there on that issue as well. So there's a bunch of issues in this case, and it's in court right now. Every single one of their motions to have their medical cannabis authorizations presented in court have been shot down by the judge, which is typical in federal cases. And it also leads us to other problems of rights of the patients. So without an oath of office, the sheriff had no right in any way, shape, or form to conduct a search or an investigation of these people, nor did he have a right to, in essence, hire the helicopter that was owned by the Office of Air and Marine to investigate these people either. And so the flight was hired by the Sheriff's Department. It was flown for the Sheriff's Department. It was called a marijuana eradication flight. And they decided to go after medical cannabis patients rather than go after criminal activity. So with no criminal activity, they have no case, and that is what we are trying to establish in this case. And here in Washington State, where we have passed Initiative 692, we have an issue where we really need to make sure that the people's will in this state is upheld, and our Constitution guarantees us the right to do so. And our Constitution in Washington State also supersedes the United States Constitution for any government agent working within the state of Washington. Actually, for any person in the state of Washington, they have to follow the Washington State Constitution. So we have quite a number of issues in this case, and something that we definitely need to bring forward. But this oath of office right here is a very important part of it, which definitely demonstrates that the sheriff had no right to be there at the time he was there. In fact, because he never filed his oath of office appropriately, we are in the situation where there is no possibility that the sheriff can redeem himself. In fact, at this point, what he did by coming into the home and holding these people hostage was to kidnap this group of people. No oath of office means he has no right from which to perform these duties. When the federal government chose to come into these people's homes, raiding them without actually having them directly involved in criminal activity, what the federal government has done is the federal government has taken responsibility for the circumstance that happens afterwards. And quite honestly, since the judge is in the position right now of denying these people their rights to a defense, we have a situation where the federal agents who came in and did this are also responsible for what happens after the fact. This is just like any other case where if I help somebody rob a liquor store and somebody is harmed in that action, I am directly responsible, even if I didn't go in there and harm anybody or lead to anybody's harm. If I just drove them there and dropped them off, I am just as responsible for the action as the people who went in. So when the federal agents broke into these people's homes and kidnapped them, and the state agents as well, they did this without any authority of law. They would have to have illegal activity, which they did not have. And Section 823 of Title 21, the United States Controlled Substances Act, Section 823, Section B, actually states specifically that Schedule 1 and Schedule 2 drugs will be regulated by the states anytime, and state regulations for manufacture and distribution for medical purposes of Schedule 1 and Schedule 2 drugs. So we clearly have the state regulating it. We've chosen how to regulate it as the state. In fact, the Scott Shoup case, which overturned 3 felonies for the owner of Change, the dispensary in Spokane, the first one to open up, where he was convicted of 3 felonies. Those 3 felonies were reversed. So that demonstrates a clear conflict in law between state and federal law. And this conflict is very important because when the conflict is applied, then we have the void for vagueness doctrine, or what is also referred to as the rule of lenity, which needs to apply in this case, so that these people can have a fair shake because they did not know they were violating the law. It's very clear that they thought they were within the law, especially when state agents come in who are telling them that they are state agents, even though they didn't have a proper oath of office in place from which to perform their duties. Tell them that they're now within the state guidelines. We have a clear case of the rule of lenity. And that's the most unfortunate side of this whole thing, is that these people really thought that they were following the law. This is not a case of somebody trying to, confuse the government. This is the case of the government confusing the people. And that cannot happen. When the government confuses the people, the courts confuse the people, law enforcement agencies confuse the people, the rule of lenity has to apply. That is what protects us, the people, from at any point in any state of our understanding of law violating it intentionally. Mens rea is what we have to have. Mens rea means criminal intent. Without mens rea, we did not violate the law. If somebody hand painted a crosswalk across the road and I thought it was a crosswalk, so I crossed there, if an officer gives me a ticket saying that I was jaywalking, they cannot give me that ticket. It cannot be upheld in a court of law. The reason it cannot was because I did not know I was violating the law walking across that crosswalk. So if that is the case, that means the same thing in this situation. These people clearly had no clue they were violating the law. They were clearly unaware that there was an issue that existed. They were growing what they thought was the correct number. They even had state agents come and quote unquote correct them and fix their situation to be in compliance with the law. Now they come back with federal agents and say, haha, but we got you with the federal government. That is clearly entrapment. It is clearly set up. There was no question from the very beginning that these people were trying to do what was right, and they were there to respond. I'm going to quote real quick out of Criminal Justice, 4th edition by James NCRD, 1993, I believe was the year this was published. Let's see here, we have page 59. Law sanctioned by state. Under the American system of law, the maxim nullum crimen sine pena, no crime without punishment, dictates that a law must be written, that persons cannot be tried for facts that are not crimes in law, and that persons cannot be punished for acts for which the state provides no penalty. And this is where we find these poor Kettle Falls 5 in this particular state, because there is no punishment in the state of Washington for medical cannabis production, unless you are violating the law, which they were clearly told that they were not in violation of state law. In the absence of such doctrines, a social order would quickly fall into a state of anomie. A state of anomie is defined as: anomie is a condition within a society or group in which there exists a weakened respect or lack of adherence to some or most of the norms. If a legal system had no written law, any act could potentially be construed as a crime at the pleasure of the court or state, resulting in a situation of iron-bound tyranny. Furthermore, if certain types of behavior were defined as crimes but no penalties were embodied in the law for their commission, then again, a hopeless level of confusion and disregard for law would likely ensue. And that is where we find ourselves for certain today, because now we are clearly in a state of anomie. The reason we're in a state of anomie is because the general public does not believe that the federal government or state government in any way, shape, or form represents them, and they have evidence of that in the courts. Every single day, people go to court for crimes that they have not really committed, and they're being punished for crimes that they never really committed. And as I was told myself when I came into the Stevens County Court, that driving while suspended in the 3rd degree was not possible to win, I beat that ticket and got my case dismissed with prejudice without an attorney. So it is possible, and it is true that just because somebody accused you of a crime doesn't mean you committed a crime, and no one can make that judgment without being seen by a jury first. And that's where we find these poor people. The federal judge has thrown out every single one of their motions to have their medical cannabis case heard as a medical cannabis case. In essence, completely cutting them off at the legs so that they have no ground from which to stand on. They are now set in a position where there is no option but to be convicted.